Preparing to Testify in Confession Cases, Part 1. In this presentation, we will detail the strategy defense attorneys may use and the questions that they may ask of the interrogating officers in an effort to get the defendant's confession suppressed. Please note that the content of this presentation can be found in a written document. Specifically, we have an investigator tip entitled Preparing to Testify in Confession Cases, which essentially mirrors the content of this video presentation. You can find that on our website, Reid.com. Deja Vishnay is a criminal defense attorney who has specialized in homicide and false confession cases, as well as suppression, trial skills, and providing effective counsel in criminal defenses. In her book, Suppressing Criminal Evidence, and in several of her articles, Vishnay offers a number of strategies for attorneys to get potential evidence, including confessions, against their client suppressed. When the prosecutor and investigator understand the strategies that the defense may employ in challenging a confession, they'll be better prepared to respond to the challenges and to testify about the circumstances and procedures the investigator followed in obtaining the confession. In her article, Cross-Examining Police in False Confession Cases, Vishnay outlines how a defense attorney should prepare for the cross-examination of the interrogating officers, detailing what questions should be asked and what issues should be raised. She states that in cases in which the interrogation was recorded, the defense attorney should carefully review the recording and transcript together to make sure the transcript is as complete and accurate as possible. Then she recommends you should, quote, count up the number of times your client denied committing the offense. So police can no longer get away with testifying they don't know how many times they denied it or it was just a few times, when in fact there are many denials reflected in the transcript of the interrogation. Other details of the interrogation should also be analyzed in their totality: the number of times the police cut off or interrupted the client's denials by telling them that they didn't believe them, how many times they told the client they had a strong case, any false evidence ploys that may have been used, explicit or implicit claims that confessing would be helpful, number of references to what the DA or court will do, and how the client could only help himself by making statements. She advises be sure you are prepared to exactly document what facts the police revealed to the client about the case that subsequently became the foundation of the false confession. Familiarize yourself with the exact questions asked. How many times did the police ask leading questions that implied or suggested the correct answer, or gave the client a few options to select from? According to Vishnay, the goal of the trial cross-examination is to persuade the jurors that the police interrogation techniques were able to overcome an innocent person's resolve and make them think that it was in their best interest to give a confession to a crime they did not commit. She states, quote, the prosecutor will have presented the interrogation simply as an interview, where the police politely asked questions and the client came forward with the true story of their guilt. You must remove the sparkle from this story and establish that this is a fictional version of what occurred in the interrogation room. Question the detective about the difference between an interview and an interrogation. Since these are terms of art in police training and practice, the witness can acknowledge that at some point they did move from an interview to an interrogation. This will make the prosecutor's repeated references to what happened when the detective interviewed the client seem disingenuous. Question the detective about the total control the police maintained over the environment. Only they could lock or unlock the door, provide food and water to the client, let him use the bathroom, let him take medication, let him communicate with the outside world, let him leave the room or go to sleep. Detailed how the police physically positioned themselves vis-a-vis the client, their movements during the interrogation, and how and why they touched the client if in fact they did. Ask about their tone of voice and how it varied during the interrogation. Be sure to elicit a description of the extent to which the client was held incommunicado from the outside world. Make the amount of time of the interrogation come alive by figuring it out in terms of seconds. Have the detective take a watch with a second hand and wait in silence for a full minute. A minute of dead time in the courtroom will seem to go on forever, and you can use this to vividly illustrate how much time was spent interrogating your client. Note, any claims of DNA or other quote-unquote foolproof scientific evidence and whether the police engaged in puffery or outright deceit. The recording may reveal that the detectives posed the existence of such evidence in hypothetical terms, such as, what would you say if I told you that your DNA and blood from the scene is being tested at the crime lab right now? It should be pointed out that this method is used by detectives so they can deny in court that they lied to the client about non-existing evidence. Explore the interrogation themes. If the detective claims he doesn't know or what you mean by this, briefly explain what a theme is and ask if he or she used it. Point out that these themes are designed to make the client believe that if they confess, they will be prosecuted on a less serious charge than what the evidence looked like without the confession. In part 2 of preparing to testify in confession cases, we discuss themes in some detail as well as the Reid technique. What you are essentially trying to get the interrogators to tell you is how they deliberately moved your client from a denial to an admission of involvement in a crime they didn't commit. Often the recording will reveal that the detectives told the subject to tell the truth or that they just wanted to get to the truth. Point out in cross that they already had decided that the truth could not be that your client wasn't involved or that he had an alibi, that he was an innocent bystander, or whatever other facts you might have to point to their evidence. If your client has particular vulnerabilities, such as mental or physical health issues, or developmental disabilities, or as a juvenile, you should explore what the police knew of these vulnerabilities. Point out their lack of special education or training in this area and how they failed to alter their standard interrogation or operating procedures to take the problem into account. After completing the cross chapters of how the police obtained your client's admission of involvement, explore how they developed the post-admission narrative. Use specifics from the recording to show how they led the questioning of the client. If there are points in the tape where the client claimed one version and they informed him that things occurred differently, or that his explanation was not true or accurate, point this out. You must show the jury in a blow-by-blow detail how the police shaped the statement. Often police investigations come to a halt once a confession is obtained from the suspect. Point out the lack of investigation to corroborate the confession and that good police work would entail verification of a confession. In addition to the above, in her book, Suppressing Criminal Evidence, she includes the following material as potential areas of inquiry when examining the investigators. Did the client specifically state he wanted a lawyer? Did he name a particular lawyer or ask for a public defender? Did he ask how and when he could get a lawyer? How did the police respond? Was he told that getting a lawyer would mean that the prosecutor would review the case without the client's statement or input because the client could not have a lawyer until after he was charged? Was he told this would disadvantage him with the prosecutor? If he didn't ask for a lawyer, did he tell the police he didn't want to talk anymore? What words did he use when he said this? Did he specifically say he didn't want to answer questions at all, refuse to answer on a particular topic, or refuse to answer particular questions? Did he ask to go back to his cell, to go home, or to make a phone call before answering any more questions? How did the police respond to his requests? Did they use delaying tactics or offer to stop questioning him about the crime and instead to talk about another subject? Did they move closer to your client, touch him at all, or tell your client to look at them directly? Did your client assert his rights at the outset or sometime in the middle of the interrogation? If it wasn't at the beginning, why did he initially agree to talk and then decide to try to stop the questioning at that particular point? If the police did honor your client's rights and talk to him again later, ask the same questions of your client enumerated above. Find out if the subsequent attempt was made by a different set of officers. Was your client questioned regarding the same matters? Ask whether your client was ever handcuffed, told he was free to go, or ever asked to leave, and whether the police transported him to a place to be interrogated. Was the door to the interrogation room open, closed, or locked, not only during questioning, but during any times the officers were not in the room and your client was left there alone? How were police officers positioned relative to the door in the interrogation room? Small details are important. For example, whether the client was able to use the bathroom at will or was escorted to and from the bathroom and had access to food and water whenever he wanted. Whether the client was able to use a phone or keep his cell phone with him is also crucial information. Find out if the client came into the police building using public entrances and elevators or a stairwell. Your client's activities in the hours before his arrest may have a bearing on his ability to withstand a psychologically coercive interrogation. Find out your client's activities in the 24 hours leading up to the arrest and interrogation. Obtain details regarding how much sleep the client had the night before being questioned, what and when the client last ate, and whether the client consumed any drugs, medications, or alcohol in the hours preceding the interrogation. Sometimes there will be an initial interrogation during which your client asserts the right to counsel or the right to remain silent. The interrogation is terminated. But then later there's another recorded interrogation. At the outset of the second interrogation, police will often confirm on tape that your client has now changed his mind and wants to talk to them. If so, find out what led up to the later interrogation session, who reinitiated contact, how and where did it happen, was it a result of your client asking police questions about his case? What were those questions, and were they really about the case, or did he ask what was going to happen to other people who might have been arrested or questioned? There also may be segments of the police interrogation that are not recorded. Even if this seems benign, such as a conversation while being escorted to and from the interrogation room, find out what was said. If the tape was turned off for any reason, try to recreate what occurred during the unrecorded portions. If the recording is audio only, ask your client about movements by the police during the interrogation. How were the Miranda rights read to your client? Did the officers pause after reading each right to ask the client if he understood that right? Or did they read the rights all at once? Was a card used, or did they recite the rights from memory? Did they ask him if he wished to waive his rights individually after each segment or only after the entire reading? Did the police present Miranda warnings to the client in a way that implied the client would be better off talking to the police? If your client is a juvenile, has a low educational value, has mental health issues, or developmentally disabled, did the police ask him to explain the meaning of each of the rights in his own words? Did your client sign a written waiver or just give an oral waiver? Did the police ask your client not only for his version of what occurred, but also ask him about what should happen to the person who committed the crime? Or if the perpetrator deserved a second chance? Did they ask your client if he ever thought about or fantasized about committing the offense? At what point did they say that if a person thinks the perpetrator of the crime should be treated leniently or fantasize about the crime, that that is an indication of guilt? This concludes part one, which is essentially an advice from Vishnay to the defense attorney how to prepare to challenge the confession and the interrogation process. In part two, we will discuss statements that Vishnay makes about the Reid technique and detail how she misrepresents the various elements of the Reid technique, and we will present the correct information. Thank you very much for taking a few minutes to listen to this presentation. If you need any more information about the Reid technique, take a look at our website, reid.com, specifically our investigator tips, and our book, Criminal Interrogation and Confessions. Thank you very much.